Good morning. We are ready to resume the trial. Is there anything I need to address before we bring the jury in? I take it by your silence, the answer is no.
No, Your Honor.
Ms. were you able to email that?
I did. I emailed it to her, and I believe she got it.
All right, thank you. Now let's bring the jury in. Good morning again, ladies and gentlemen. We are ready to resume our proof in this case, and I believe the defense is still offering any proof that they might want. Mr. Belmars, you have another witness?
Yes, Your Honor, defense will call Ms. Patricia.
Ms. Kelley, if you'll come around. I'm going to ask you to step around, raise your right hand, and face the clerk.
Would you please state your name for the record?
Patricia Kelley.
Would you spell your name, please?
Ms. Kelley, draw that base of that microphone towards you a little bit, so slide it toward you so that, there you go. Thank you.
Okay.
And would you state would you spell your name, please?
Patricia, Kelley, Kelley.
Ms. Kelley, how do you see your role as a grandmother?
My role as a grandmother was to take care of my grandkids in any way possible, whatever they needed, whatever my son needed, or even the mom when they fell short. My role was to step up and make sure the kids were okay.
If your children or grandchildren needed a place to stay, what would you do?
I would take them in.
They
No
needed-
questions asked.
If they needed clothes, what would you do?
I went to the store and I bought the clothes, made sure they had their Christmases and birthdays, holidays,
If they needed food, what did you do?
made sure they were fed. There
In,
was some problem for that.
in May of 2020, or the summer of 2020, was this a planned summer trip to grandma's house, or was it, as you put it, you stepping up again for the children?
Stepping up to take, my son said he had some issues, and I didn't really get into what it was. I can't tell you exactly what it was, but he needed some help. And as usual, I got the kids.
And did you provide everything while they were there?
Well, yeah, I primarily had kept things at the house. I didn't send everything home when they returned. I had my own things for them, make sure they was comfortable, swing sets, whatever they needed, keep them busy.
Did Mr. Clinton provide any assistance, financial support or anything while they were there?
He wasn't able to, and I didn't expect him to. It was my pleasure to do so.
Your Honor, may I approach the witness?
You may.
Ms. Kelley, do you recognize that image?
Yes.
And what do you recognize it to be?
This is where my vehicles are parked, and this is my neighbor's house, the fence that separate our properties and where we would come sometimes and talk, kids will go over the fence and visit with them or see them in the yard, they see us. Anybody that came to the house, you can see them right there from our driveway. It was kind of adjoining area, but separated by the fence, but it's not a fence that you can't see through.
And does it fairly and accurately depict what you would see from your parking area looking towards that house?
Yes.
Your Honor, I'd ask that that be marked and entered as an exhibit.
What's the exhibit number? 5? Exhibit.
And in May of
9.
in May in the summer of 2020, who lived in that house?
Mary Smathers, Bill Smathers, and their 2 daughters would visit them a lot. And I think Nedra at that point had come to take care of them. So Krista, she was in and out. They would come and see about them.
So Miss Nedra Patterson, who we heard from yesterday, when she was talking about the porch of the house, that was what she was talking about?
Yes.
Your Honor, I'd ask that we publish that exhibit to the jury, please.
Pass it to the jury, if you will, please.
Did you ever tie Raynell Clinton Jr. up with a rope?
No. No.
Did Junior Clinton sustain any injuries while he was at your house?
Oh, he did. He's a rough player. Yeah.
We heard about an injury to his head. How did that happen?
I believe at that instance, he was walking up the steps from the garage and he lost his balance. And before I can catch him, he hit himself on the floor. Yeah, just.
And we heard about some scratches on his back.
Oh, that would be when him and Jeremiah got into a rough housing. They pushed and shoved each other. I had some towels on the wall, and he was the one at the back of and caught his arm area into the bricking on the wall.
Your Honor.
You may, if you.
Ms. Kelley, do you recognize that image?
Yes.
And what do you recognize it to be?
This is the area where I had installed, let's see what you call it, backsplash on my counter. So this is the area where he shoved them up to it, and I stacked these right here. They weren't like that initially. I had to put them there, and I left them there because I wanted Renell to see them when he came.
Okay. And when you say you stacked them up, so how did they end up off the cabinet and on the floor?
Oh, because they had got into it so rough, they came off the wall.
And you said you left it in the condition that it was, but you stacked the tiles up.
Yeah, I stacked them, I left them in the area where it was.
And does that photo fairly and accurately depict what happened after you had cleaned the tiles up?
Yes.
Your Honor, I'd ask that that be marked and entered as the next exhibit, please.
Mark it as Exhibit 10.
And to be fair, that picture was taken a long time after the fact. But what you're saying is you left it there.
Right, and it wasn't a long time after the fact because I took the picture because I wanted Renell to see. I had a habit of taking pictures of the kids throughout everything that they did. So those, I did stack them, but I told Renell about them. And when he came, that's the first thing he wanted to see and he wanted to know what happened and why they had gotten into it.
And does it still look like that now today?
It does.
So how did Junior get the marks around his arms, here on his forearm and down by his wrist?
I'm not sure about his forearm or wrist. I know we had poison oak. And that's all I can know about that. I don't know anything about upper, I don't know anything about that.
Now, when he got poison oak, did you get it as well?
I did. I
And,
have left scars.
and did you attempt to treat Junior's poison oak?
I treated both of us, yes.
Okay. And how did you treat his poison oak?
Well, initially, it started out just like a little blemish-like type thing. Then I started spreading, so I went out to Walgreens. I talked to the pharmacist and asked them how to treat the area for us and what to do with it. And the pharmacist explained what to do and told me what products to buy.
And did you buy those products?
I did.
Okay. And what type of products were they in?
Calahist, Benadryl, Epsom salt, and I had goals already at home from my son. He had surgery, so I already had the goals at house.
Did you buy any hydrogen peroxide?
I didn't buy any hydrogen peroxide. That wasn't suggested to me to use.
And have you used both Epsom salt and hydrogen peroxide in the past?
Separately, on myself, yes. Yes.
And what's your experience? What does Epsom salt do with wounds?
Epsom salt dries it out. It also, like if you're inflamed, it takes the pains out of your muscles or anything like that. Your feet are sore, you would soak it in Epsom salt and water, get the soreness out of you, anything that you're trying to dry up.
So, and what does hydrogen peroxide do when you put it on a wound?
It bubbles
Bubbles.
and causes it to be wet.
And so, when you're using Epsom salt versus using hydrogen peroxide, your goal was to dry out the wounds.
Yes. To get them to heal. Yes.
In addition to the ointments and the Epsom salt, what other steps did you take to attempt to treat the poison oak?
Oh, well, they suggested that you don't let any of the areas touch each other. We slept on the same area. So I put the socks on the hands, but I cut the foot out of them. Also, we had long socks that they use for wrestling, so I put those on their legs. I had socks that came up to my knees. I had those on, and I had myself covered so that we didn't keep transporting around.
And during the day, would you wrap them up with anything?
Yeah, especially if they wanted to do anything, like Junior liked to lay on the floor in the kitchen, not in the kitchen, in the dining room, on the floor, wrap them up, they watch TV, things like that, but couldn't keep it wrapped because you gotta let it air.
Okay. And what would you wrap it up with if you wrapped it up with something besides the sleeves, if you will?
The goals.
Now, back to the Epsom salt. So you said that you had treated Junior with Epsom salt.
Yes.
And when you did that, tell us, how did you treat him with Epsom salt?
Well, I had a container, I think it was like an old yogurt container. I put some warm water in it, put the Epsom salt in it, then I would put his hand in there. He didn't want to keep it in there, and I put it back in there. He didn't want it, so I just gave up on that one for him.
And did you also put your hand in Epsom salt?
I did not, because in that same instance, my sister called, so it didn't happen for me. But as I was speaking with her and talking to her, she said it wasn't a good idea for Epsom salt.
Okay. And so after that, did you ever put his hand in Epsom salt again?
No,
And you didn't put Epsom salt on your poison oak?
no.
And have you had poison oak in the past?
I think that was my first time having it. I've had it since then.
Okay. And have you ever had it on your palm versus the back of your hand?
No, I had it on my palm, but I did have some on the back of my hand.
Okay. All right. Do you find that it's your palms are harder for things like that to affect, or your skin on your palms is tougher than other parts of the body?
Well, yeah, it's it's a rougher skin, I guess.
So when you were treating Junior, what was your goal? What were you trying to accomplish?
To heal his wounds as well as mine.
And what concerns did you have about his wounds? I mean, why did you decide that you should, take action and not just let it be?
Well, I don't know that anyone wouldn't treat a kid that needed. I don't know how I would have done that, not cared about it. And I know that they said don't bring him to the hospital because within COVID unless it was an emergency. So I went to the Walgreens.
Okay.
I figured they would know.
All right. And you did, in essence, you did your best efforts to keep the wounds clean, dry, and
Yes.
keep them from spreading.
Yes.
I want to talk about this clock. Did Junior in fact break a clock?
He did. He did.
Did he get injured by breaking a clock?
I don't think he had been injured. I think he might have had a little nick or two. I don't call anything major for it.
And under my approach a witness?
You may. Did you want that photograph of the backsplash demonstrated to the jury?
Yes, Your Honor. Thank you. Ms. Kelley, do you recognize that image?
Yes.
What do you recognize it to be?
This is the glass that was left on the floor that was broken out of the clock.
Okay. And does it fairly and accurately depict the condition of the clock after it was broken?
Yes.
Your Honor, I'd ask that that be marked and entered as the next exhibit.
It would be Exhibit 11.
Did you send that picture to anyone?
I sent it to Raynell Senior.
Okay. And what happened after you sent him the picture?
Well, it was early, so I sent him a text with the picture telling him that Junior had broken the clock. And shortly after that, he rang me back on the phone.
Okay.
Then I put him on the video call.
Okay. And what happened when you put him on video call?
He talked to myself and he talked to Junior about the incident.
And so could you tell us what happened that day? So after that, what happened that day?
After that day, when Jeremiah got up and Levi came downstairs, I then got us ready for the day like we always do and went outside we had to go outside every day, every morning. I went out to do my garden. They came out garden with me. They played with their toys, whatever they wanted to do.
Before I ask about that photo, did Junior end up in timeout that day?
He did.
And do you remember what he ended up in timeout for?
Well, because they was out playing with the kites and they had kept getting tangled up. And so I put him in timeout because he kept ramming Jeremiah kite with his kite, because he's a rough player. He's rough about everything, so I put him in timeout.
And do you recognize those photos that I passed up?
Yes.
And what do you recognize those to be?
Junior sitting in timeout.
And who's the, do they fairly and accurately depict the scene there on the porch?
Yes.
All right. Your Honor, I'd ask that those be marked and entered as collected exhibit.
It would be collective exhibit. Next in order would be 12, I think. Is that correct?
And who was that in the background of one of those photos?
Oh, that's Levi, Uncle Levi.
And was that the type of discipline that you used with the children?
Yes.
Now, Your Honor, may I approach the clerk?
You may.
We're going to pass up Exhibit 8, which is the binder of photographs from Vanderbilt Hospital. Will you look through those photographs, Ms. Kelley? Ms. Kelley, my question is, did Junior's hands look like that when he left your house?
No.
We heard from Mr. Raynell Clinton Sr. about, before the children left, that y'all wrapped up Junior in gauze. Why did you do that? What were you doing there? What were you trying to accomplish?
To keep his wounds clean and to keep him from making further contact. Can I say something?
Were you,
You can only answer questions of your lawyer.
would
Well,
you,
this is, sir, is about, he asked me about the picture. The one I do recognize is this one.
Ladies and gentlemen, step across, if you will, please. Out of an abundance of caution, I wanted the jury out of the room. You really can't ask me questions. You need to just talk to your lawyer and let your lawyer ask the questions. Go ahead and ask him what it is that you want to say.
Oh, I was just trying to answer the question that you asked me about which picture that did he look like. And by that time, I hadn't got to this one. So this is one that I do recognize that he,
okay, what page number is that?
21.
Okay, all right.
All right, so you wanted to just bring to his attention that you did recognize one of the photographs, right? And all I was trying to do is to ensure that the jury is not exposed to something that's not permissible. So we'll bring the jury back in now and let you, you will ask her the question, just to say that, is there something you now recognize?
Yes, Your Honor.
All right, ladies and gentlemen, I've told you all along, I tend to err on the side of caution about something that, I don't want something coming out that's inadmissible before you, but this was just a situation where she wanted to bring to your attention and to Mr. Bellmeyer's attention and my attention that there was one photograph she recognized. So Mr. Bellmeyer's, go ahead.
And so, Ms. Kelley, you wanted to bring to our attention that there was a particular photograph that the injuries did look like what they looked like when Mr. or Junior Clinton left your house, correct?
Yes.
And what photograph is that?
21.
It's page number 21 in the binder.
Yes.
And so that is an image of Mr. Clinton's right hand, correct?
I'm not sure what hand it is, but it's a hand.
Okay, and there appears to be a dark mark and then a lighter or a pinker mark there on his wrist. What happened to cause that pinker mark there on his wrist?
This is where his skin peeled off.
Okay,
It was getting well, and so with peel.
okay. And do you know when that piece of skin peeled off or when that happened?
I am thinking when Rainier came to get him and we were changing his goals.
Scoot that base of that microphone closer to her, please.
Okay, sorry.
So when Raynell Senior came to get the children, y'all were changing the gauze together.
Yes.
And were you doing that to help demonstrate how you had been taking care of the wounds?
Yeah, I was telling him how to treat his stuff the way that they told me to.
Okay. And what did you tell him that he needed to do?
Well, I showed him.
Okay.
We removed the gauze and we were there working on it together. Showed him the topicals that need to go on them. Showed him how to wrap them. Try to tell him don't keep it on all day long because it needed to breathe. Just telling him the same thing that they told me so he can be taken care of.
Okay. Did you have any concerns at that time that it would be done like it needed to be?
Not particularly. That's the reason why I was taking time to tell them. Yeah. To make sure.
Pass the witness, Your Honor.
Ms. Bryson, you may cross-examine.
How long were the boys at your house?
Well, they were there a long time. I got them right out of school and just about when school was getting ready to start back. So however, I don't know exactly, but I've been hearing the word 10 weeks.
So does 10 weeks sound about right?
Yeah, covers the summer, yeah.
Who all lived in the house while the boys were there?
Me and my son Levi,
And how old was Levi?
13.
I want to talk about some of the photos that you and Mr. Belmaris introduced.
Okay.
Do we know what we have to do to get it to?
No, we don't have our technical experts
No, we don't.
here.
Well, while we figure out how to get it up, the picture of the tile that fell down, what kind of tile was that?
It was,
It looks like the fake brick.
well, you can call it that. It's what I use for my black splash on my cabinet.
Okay.
It's on the side of my cabinet, and that's what I decorated it with, yeah.
So was it a ceramic tile or was that hard fake brick?
I don't know how you classifying it, but I don't know.
Did it look like a tile on the front or did it look like a rock on the front?
It looked more like a bricking, like a chimney kind of
Okay.
effect that I wanted to do there, yeah.
And so we see that down here at the bottom.
Yes.
Where did you buy the tile?
Lowe's.
And what was it attached to the wall with?
See the white there? That's the glue that I put up there.
Okay.
And to put it onto the wall.
Did you
So
ta-
perhaps it wasn't too good because I was able to knock it off.
did you take this photo when it happened?
I took this photo when I had to remove the rest of the bricking. As I said, I had to clean that area up and I laid them down there and I wanted Rainiel to see what had happened there because Rainiel knew about that area because on the opposite side, and I'm sorry, I don't have a picture, it has the same look. So like I said, I stacked those down there and I took the pictures of them to show that they were broken off the wall because Rainiel knew that those were up there.
Okay. So did you send this photo to Raynell?
No, I didn't. He came to the house and he saw these. I talked to him about it on the
Okay.
phone.
So you took this photo at a later date?
Not at a later date. That's not what I said. What I said is right then when I took that stuff down, put it down there, stacked it down, I called Rainiel and told him about this. Not a later date. He came on a later date and he saw it for himself
When did you take the photo?
that day,
What day?
the day they got into the scuffle.
Do you know what metadata is?
I don't know what metadata is.
So if this photo shows that it was taken in March of 2024, would that be incorrect?
I may have my pictures wrong, but I did take the pictures, and then I researched through my documents and found the pictures that I had stacked these on the floor. So if it says 2024, it may be an updated picture of my area, but that is indeed the area, and it did happen then.
Okay.
That's why it's down there. And Raynell saw that for itself.
So you also took this picture of the clock.
I took the picture of the clock too.
Okay. So let's look at this one. Did you crop something out of this image?
Crop, how?
Like, did you change this photo in any way?
No.
Okay. Because the file name says that it's been resized. Do you know why?
I don't know anything. I'm not technically savvy like that, so I don't understand what about that. No, I don't know what you're saying.
So you took this photo to document the clock and the damage.
Right.
Okay. So let's look at this. All the glass appears to be down here on the bottom. Did the clock fall over?
The clock fell forward.
Okay. How did he knock the clock forward?
Can I go
You
up
may.
here? Okay.
Judge,
sure.
may she leave the
Can I-
stand to point to the photo?
Can I?
Sorry.
She would like to leave the stand to point to the
Yes,
photo.
that's fine.
And you sent this photo to Raynell Senior?
I did. I talked to him that morning. I sent him a photo. It was real early. And see, this right here, okay, I got an answer for this.
Okay.
Okay, let me explain to you why. The phone that I originally had was broken or whatever, and they port those pictures back into you. That's why.
Okay.
So that's why it's updated, because my phone, anytime I had lost my phone and had to replace it, your pictures come back in.
So let's look at the file name here. There's been some discussion earlier in the trial about July the 6th. Is this photo taken on July the 6th?
July 16th.
16th. Thank you for correcting me. July the 16th. And you would have sent it at 5:35 in the morning?
That's why I said it was early.
Okay. So is that what time the clock got broken, or just what time you took the photo?
No, Junior was, like I just got to explaining. When I was on you can't see the chase. The chase is on the wall backwards, right? Where I was laying up there is a couch over here. Jeremiah was over here asleep.
I just asked what
And-
time the clock was broken.
Okay, it was early.
Okay,
I
so
don't know the exact time. It happened in the same.
let me try to clarify my question so
Yes,
that
ma'am.
we can get it.
Yes, ma'am.
Okay. Was this photo taken when the clock was broken close in time?
Yes.
Okay, that's what we're trying to make sure, because I didn't know if the clock was broken the night before and you took the photo early, but no.
Right.
The photo was taken around the time that the clock was actually broken.
Yes.
So did the boys often wake you up 5 a.m.?
Junior could get into anything at any time. Jeremiah, not so much. Like I said, he was still asleep. But Junior has a mind of his own, and when he wants to, he wants to. So that toy's right there. He got up, ready to play.
Where did Jeremiah sleep at your house?
He, that particular day, was on the sofa that was over here. Normally, we slept on the chase together, all three of us. I have a chase that's on this wall, and Jeremiah liked to lay beside me, and I had Junior on this side.
Did Junior ever sleep on the floor under a table?
No. They watched TV in the dining room with their feet under the table. My table is high, and I didn't see a problem with them laying on the floor watching TV or even eating their food.
Did you have other beds in the house?
I have lots of beds in my house.
Were the kids allowed to sleep in the beds?
Yes, sometimes I step upstairs in my room with the kids. But again, Junior gets up, so that wasn't a good idea because he's 3.5, and I got high stairs. So he disappeared one time. I didn't know where he was. I was concerned about him. I found him downstairs. Wasn't a good idea. So I tried to make it my business to stay on that lower level. So yes, I have plenty of beds.
Let's talk about the kites.
Yes.
And I have tried to fly kites many times.
Sure.
I've never been very successful with them. Were the kids able to get them up in the air?
You have to run at a fast rate, and you have to hold your hand up, and you have to navigate it. And you have to do it while you're running.
So were they able to keep them in the air, or just when they were running, the kites were up?
You have to run and have them up.
Okay. And how was he ramming his brother's kite?
Can I stand up and demonstrate?
Sure.
Okay. I got 3 people out flying kites. But in this area, this area, person has this string up and running. This person runs across that person area. Kites can crash. Or he can just intentionally ram at it.
And you took multiple photos of him in timeout and sent them to his father.
Yes, because I was showing Raynell.
You're showing him he's a bad kid.
No, I was not, ma'am. What I was showing Raynell is an alternate way to disciplining his kids other than whipping his A with a belt. So my method is, I'm a homeschool teacher. I had parenting classes when my kids were growing up, and that's what we were taught. Timeout is the best way because a spanking, it doesn't last long. But if you put them down in the corner somewhere, they can't play, then they have time to think about the things that they've done, and they want to get back up. So they're going to make the apologies, and they're going to do better and go on. So it was a way to show Raynell, because Raynell Jr. was getting ready to start school. And he's very running bunches. He gets at it. Dad whoops him with the belt. So I was showing him the timeout method so Junior could get familiar with it so he can go to school and be productive with the other children.
Do you have any scars from your poison oak?
I do.
Judge, I would ask that she be over to walk over to the jury and show them her wrist.
All right.
When did Junior get into the poison oak?
I don't know the particular day that we got into Poison Oak. We were working in the front yard, and somewhere along my fence line, it happens to me even now when I cut, even when I'm on a riding lawnmower. I don't know where it's at. But I did take pictures of the brush, and I think you should have those pictures where we had gathered them and put them into the pile. So it's a thing that I taught them to help clean up. We did it on a regular basis.
So was it before or after the clock was broken? Do
It
you
was
remember?
before.
It's before the clock
It
was
was
broken.
before. Yes, ma'am.
When did he fall down the steps? Before or after the clock was broken?
That was before. I took him down to the basement, get some popsicles. I had him in my hand. He pushed the door. Both of us fell into the garage. And on the way coming back in,
Ma'am, I
he
just
fell
asked
up the
when.
stairs. I was just explaining how he fell.
It's just a when, that's a
When,
time
I don't
question.
have, it was before, it was before.
Now, in the photos, and I need to see which particular two were entered of the Exhibit 12, please. So it's summer. Is this Jeremiah's normal, not Jeremiah, is this how Junior normally dressed, shirtless, little boy running around?
Sure, because we have a pool.
Okay.
Absolutely. That's
So-
the way they like to be.
When they went over to the neighbor's house,
No,
was he like this or does he have a
absolutely.
shirt on?
No, ma'am. I would not take them out in their underwear. We had a pool. They played. They were more comfortable that way. And I let them because we're in our yard and we have privacy. So
Okay.
it's not a problem for, at least I didn't feel like it was.
And I'm not calling this out as bad. Little boys run around without shirts on. I'm trying to see when we went to see the neighbors, would he have had a shirt on?
They absolutely, he would have had his shirt.
Okay.
Wouldn't be appropriate to go to the neighbor's house without clothing on.
Okay.
I wouldn't do that. I mean, that's not something someone would do, at least not me.
Now, you told your attorney this is what Junior's hand looked like when he left your house.
It's closer to what he looked like, yes.
But none of the other injuries look right.
They are not close to, that. See a lot of that stuff on him, he left, this is more what he looked like when he was at my house.
So
I
he didn't have the blister when he left your house?
No, he did not. And that mark up there, I'm not even sure where that came from. I never saw that at all.
Did he have this?
That's not the injury that he had. You see the smaller one is where he fell on the stairs, and that abrasion right there, I don't know where that came from. The smaller one in the corner is where he hit his head and he got a nick right there. It was not this spot right there. No, ma'am. Now that, yeah, that's not for me. That, no, that was already on him when he came. That's from a way prior injury. See this right there, that little small little nick right there. That's right there. It was a little gash. It was a little gash from him falling on the stairs, just a little small gash. This right here was there, and that in his forehead had been there for something else.
Okay.
And it didn't have anything to do with me.
And what were these from again, the tile?
That's from him pushing him up against that tile. He got scraped right in there. That's all in the same area.
He didn't have this when he left your house?
He did not.
And he didn't have these when he left
He
your
did
house?
not. Did not.
With all the pictures that you took of your house and of him in timeout, did you take any pictures of his poison oak?
The pictures that I had lots of pictures. As I said, I had phones that had been broken, and I had pictures of them on the seesaw, all kind of stuff. I had everything. Unfortunately, that phone I wasn't able to recover.
So it was a different phone than
Yes.
the same timeout photos?
I have several phones. Even right now, I have 3 phones. So I did have pictures in them, and one of them was for a different service. I had Verizon, but that's when my ex-husband was on that plan. So they made me start a new plan. So that, some of those I was able to recover out of my phones that I still had, but the one that was broken, some of the pictures did not port back in.
So the answer is yes, you took photos of the
I took-
injury. Let me
yes.
finish the question.
Sorry.
Yes, you took photos of the injuries. Okay, but no, you no longer have them.
Correct.
You went and talked to a pharmacist. What pharmacist did you talk to?
Walgreens on Madison Street.
Did you buy the treatment creams there at Walgreens that day?
Yes, I did.
Okay. Did you happen to check your credit card records to see if you still have records of those purchases?
I don't know. I did not.
Okay.
I did not.
And you
don't-
said you text your sister about whether or not to continue soaking it in Epsom salt?
No, I didn't say I text her. Me and my sister talk every day, my twin sister. And she called me, and while I was taking care of Junior, he didn't want to keep his hand in the bucket. I gave up on that, and I started to talk to my sister. My sister is a registered nurse. And I did discuss with her about Junior and his injuries.
Is your sister still alive?
My sister is very alive. My older sister
Okay.
is deceased. My twin sister is very much alive. Thank you.
Nothing further, Judge.
Redirect, Mr. Bellmeyers? Thank you, ma'am. You may step down.
Thank you.
Bellmeyers, you may call your next witness. Bench has rested. Does the state have rebuttal proof? You may. Do you need a long opportunity? You want me to have a break or? All right, ladies and gentlemen, in order to give the state an opportunity to decide whether or not they want to present any further proof, then we're going to take a short recess. If you'll step across, we will resume, and let's make it about a 10-minute recess, please.
All rise.
Well, it was indicated at one time or another that one or both of you wanted to have some sort of input or have something to say. Is there something you need to address?
Honor, I guess two things. On page 12, there's a long paragraph that says to find the defendant guilty of this offense, you must also find a reasonable doubt the removal or confinement was to a greater degree, and goes on. That's included in the jury charge for aggravated kidnapping and for kidnapping. It's also in the pattern jury instruction for false imprisonment, but it's not in this jury charge. We believe, or I would submit that it needs to be in that, in under false imprisonment as well. And then, Your Honor, I brought or mentioned yesterday regarding the defense of necessity. It's Tennessee Pattern Jury Instruction 40.05. It is a defense, it's not an affirmative defense, so it is a defense that is included in the defendant's plea of not guilty. That the defendant reasonably believed the conduct was eminently necessary to avoid harm, and that the desirability and urgency of avoiding harm clearly outweighed.
What is the number?
40.05. Clearly outweighed, according to the ordinary standards of reasonableness, the harm sought to be prevented by the law prescribing the conduct. And it gives several definitions. If evidence is introduced supporting the defense of necessity, the burden is on the state to prove beyond a reasonable doubt the defendant did not act out of necessity. The testimony from Ms. Kelley was that she tried to treat wounds, that she put Mr. Junior Clinton's hands in Epsom salt. When she did that, or shortly thereafter, she learned that that was not appropriate, and didn't treat herself in the same manner after learning that. So that could go to that may very well have caused the blisters that came up on his hands later on. That she may have caused burning when his hands were placed in the Epsom salt. Furthermore, submit that she said she put him in a yogurt container. That may explain why the marks below on the lower wrist and hands are different than the ones further up the arms. And so that's a question that the jury's going to have to answer, whether they believe that that could be the cause of these injuries. And so for that reason, we feel like we have fairly raised necessity as a defense, and it should be charged to the jury. Again, it's a defense. It's not an affirmative defense. It's included in any plea of not guilty.
Judge, looking to Johnson v. State, which is 531 Southwest 2nd, 558. Necessity is instructed where the proof fairly raises the defense, and I would submit to the court that it has not been fairly raised. The testimony regarding poison ivy is incredibly suspect, and was rebutted by all medical proof. So what we have here is not poison ivy. We have wounds from tying someone up, and this instruction would indicate that it may have been necessary to tie the child up. So I would say it has not been fairly raised.
What about the instructions that he was wanting to add to false imprisonment?
Defer to the court's discretion.
Let me deal with the situation regarding the defense of necessity. The defense of necessity charge states the following: it is defense to the offense, and this would be aggravated kidnapping. I'm sorry, aggravated assault or aggravated child abuse, I'm sorry. It is a defense to the offense of aggravated child abuse that the defendant reasonably believed the conduct was immediately necessary to avoid imminent harm, and the desirability and urgency of avoiding the harm clearly outweighed, according to ordinary standards of reasonableness, the harm that sought to be prevented by the law prescribing the conduct. I do not find, number one, the defendant testified that she denied ever tying or restraining the young man to the chair. That the state's proof has been that the young man testified he was tied to a chair. He stated that in his testimony here in court. He stated that in his he said he was tied up, let's put it that way. He said he was tied by his grandmother when he testified here in court. He said he was tied by his grandmother when he gave the child advocacy statement 4 years before that, when he was only 3.5 years old. That has been consistently his statement. All medical proof in this case has indicated that this injuries suffered by this young man were the result of being tied or restrained. And as a result of that, the necessity defense would not be brought into play by simply saying it was necessary to use Epsom salt on a poison ivy, because that's inconsistent with everything that this case has indicated in the way of proof. Had she taken the stand and said, I had no choice but to restrain him in some way because of his recklessness or rambunctiousness, and therefore I had to take steps to restrain him, that would be one thing, but that's not the proof in this case. She denied tying him, restraining him in any way such as that, and offered an explanation of poison oak, treating the poison oak, and then binding his injuries with a cloth or some sort, and that, in my opinion, was not sufficient to raise the defense of necessity. So therefore, the defense of necessity will not be charged. And if I'm understanding correctly, you're saying that the false imprisonment should also include the charge regarding false imprisonment should also include the additional language. Is that correct?
Yes, Your Honor, that's correct.
Any reason why that wasn't raised before now?
In the jury charge, when I was looking at that paragraph.
Well, obviously, I had given you a copy, and when I came out here, before I ran the copies for the jurors, I was wanting to know if there was any issue regarding it. I will grant your request to include that, but that means we're going to have another delay while we revamp this final decree. Would have been better had you brought that to my attention before I took this last recess.
Hunter, when I,
You'll hand one of these to each of the council tables. This is the final charge, and that addition was added, and we're now ready. Are you going to call any additional witnesses? All right, then we'll bring the jury out. All right.
And, Your Honor, I would renew my motion for judgment of acquittal with the previous arguments. However, I would add that with the kidnapping charge, there are 3 cases that are instructive regarding parents of the child or someone acting as a parent of a child. And I did not articulate that properly initially. Goes to if the person was a parent, and it's been clearly litigated regarding parents, I think here it's pretty clear that Ms. Kelley was of the third sort. She was responsible for the welfare of the children that were with her at the time. If it is a parent or someone that fits in that category, then the only way it can go forward as being kidnapping established by force, threat, or fraud, then the state must have alleged in the indictment itself the mode, similar to aggravated assault caused by serious bodily injury. It has also been litigated in the past, and it's included in those cases, that it's not a pretrial motion, it's not a motion to dismiss, because until the proof is heard, it can't properly be argued before the court. And so I would submit because of that, aggravated kidnapping or false imprisonment should not go forward. It should be dismissed through motion for judgment.
They have a response?
Judge, she's not a parent. She's not. And other than that, I'll stand on my previous argument.
All right, the court finds that the defendant in this case does not fit within the category of a parent, and the fact that she may have been a caregiver at the time does not qualify her as a parent, even though she may have been a grandparent. I will review these cases at a later date, and if I find that I'm in error in that, then I'll certainly take the steps to correct it. But at this point, with the court's finding of the proof, I do not find that the motion should be granted, so therefore it is denied. Bring the jury in.
You have 2 main questions to answer, and I told you about them in my opening statement. And they were answered early on in the testimony of your very first witness. What happened and who did it? And when Junior testified and he was asked, "Why are you here?" he said, "My grandma tied me up." And you can summarize the entire case in that one sentence. But you don't just have the testimony of Junior. You have a full picture here to really understand what happened and why you can trust Junior's statement. Now you have to make that decision. You have to decide what happened. But here's some of the proof that you heard. Junior was a very active and lively child. You can see that in the photo that the DCS worker took at Dad's house. You see that spunky personality, the same spunkiness you saw on the stand with his eyes only visible when asked a question and he would say, "Yep." That's the spunk you normally see from this kid. You see that in the pediatrician's records, as Dr. Aquino told you that when he normally came in, he was so full of life that even his doctors noted it in his record. But the day he came in August of 2020, something was different. Something had happened to this child. Something traumatic that was causing a shift in his entire personality. He wasn't lively. He was withdrawn. He was quiet, reserved. And then you heard from the doctor, well, you also heard from Miss Deese the same thing. He was withdrawn, quiet. She observed that the dad and the son behaved as she would expect, that the child was afraid when dad stepped away. Then you heard from Dr. Jones, and he used this phrase towards the end of his testimony as he kept getting asked about alternative theories. Could it be this? Could it be this? And he would say, if you were looking at that one picture in isolation, maybe, but with this constellation of injuries. Think about that mental picture. The stars, so many of them lining up that it creates this picture of what happened to this child. You know, it's interesting with this constellation of injuries that none of them identified by the defendant act involved no injuries and no gauze was noted by the witness Nedra Patterson, the neighbor who said there was nothing wrong with that kid. She didn't see any of these. With this constellation of injuries, Dr. Jones told you that they would have occurred within the time frame that the defendant had the child. Not the 2 or 3 days before dad brought the child to the hospital. What's your timeline on these? How is dad never visited? And make sure you knew that. Dad never visited. How is he responsible for those? And let's just go ahead and address it. How is that poison ivy in a straight line? A perfect straight line. No dots here or there. A straight line. What the doctor described as a ligature. Something tied so tightly that the friction from that tied straight line created those marks. And let's look at those fingertips. Because we're going to look at them and we're going to come back to them. That backflow pressure on those fingertips. How long did he tell you? Because I want you to keep that number in your mind and we'll come back to it. We'll talk about it again. Couldn't give us an exact timeline, but he said dozens of minutes. So we've got dozen, that's 12, make it plural, that's at least 25. Keep that number, just keep it in your head. But we see those marks, this constellation of injuries that together paint a picture that no one had to come in and tell Dr. Jones this child was tied up. No one had to come in and tell him this child had a rope burn. The doctor's independent diagnosis is a full circumference, both wrists, friction ligature. Or as we might say, a rope burn. Now, I want to walk through the charges that you have that you're going to look at and go through the elements so that you understand what pieces of the proof fit into those pieces of the charges. So for you to find the defendant guilty of aggravated child abuse, and these are the instructions that the judge is going to give you. So I'm not going to read you the whole thing. The judge is going to read you the whole thing, but we need to talk about pieces of it. For aggravated child abuse, the defendant knowingly, other than by accidental means, treated a child in such a manner as to inflict injury. Okay. The act of tying a rope around both wrist of a child, you have to take the time to tie multiple knots around the wrist of a child who probably doesn't want to be tied up, probably is not being still and presenting his hands to be tied up. How much time do you think that took for her to know what she was doing? Other than by accidental means. You can't accidentally tie a rope around both wrists of a child. The acts of abuse resulted in serious bodily injury. Okay, you're going to get definitions to that. You don't have to try to guess what that means. And there's going to be a lot of medical terms in that. So we're going to walk through those a little bit. Here are some of the definitions you will hear in serious bodily injury. Extreme physical pain. What did Dr. Long tell you? At the time that this happened, it would have been very painful. Okay? Protracted or obvious disfigurement. Let's look at the pictures from 4 years later. Today, you can still see those marks. Are they healed? Yes. Are they still there? Yes. Will they be there the rest of the child's life? We don't know. What did you also see in his interview? If you'll go back to the last one. Okay. So included in the definition of serious bodily injury, you have protracted loss or substantial impairment of a function of a bodily member. Think about the interview that you saw in September, a month later, where a left-handed child wouldn't draw with his left hand, where he would barely hold the paper with his left hand. Think about the physical therapy records that you heard about, where they would try to throw a ball and he would catch it with his right hand and his left wrist. Where he would climb up the slide and he wouldn't grab the slide with his left hand. Physical therapy records are in November. By all accounts, these injuries would have happened weeks to a month before August. That's 2.5 months later. Serious bodily injury includes, but is not limited to, second or third degree burns. You heard from the doctor. Partial thickness burns, like this child had, would have been second degree burns. Injuries to the skin that involve severe bruising or the likelihood of permanent or protracted disfigurement. Okay. The final element of aggravated child abuse is that the child was less than 8 years of age. Junior would have been about 3.5 when these injuries happened. He was 3 years, 8 months at the time he went to the pediatrician, taking that timeline back 1 month, 3 years, 7 months. If you'll go to the count 2. The language you would get to explain aggravated kidnapping is that the defendant knowingly removed or confined another unlawfully so as to interfere substantially with the other's liberty. So let's talk about that. We've discussed that this was a knowing act. Removed or confined. Okay. That doesn't mean that the child was stuffed in a car trunk and driven somewhere. It means that the child was unable to move freely. Now, we're not talking about timeout. Okay, kids can be put in timeout. We're talking about it being unlawful. So what you're going to hear about for unlawful is that it was accomplished by force. Or in the case of a person who's under the age of 13, accomplished without the consent of the parent. I asked Dad, did she have your consent to tie your child up? No. Is the act of tying a rope around a 3.5-year-old's wrist, again, do you think that child would have sat and held his hands out to be tied up? Or do you think force would have to be applied to still a squirming, active 3.5-year-old long enough to get him tied up? The second prong of that is that the defendant did so with the intent to terrorize the alleged victim. So let's go back to those 24 minutes. What is something in your life that takes 24 minutes? Maybe watching a favorite episode of your TV show. You sit through an episode of Friends. You're going to sit 25 to 30 minutes. Now, what if instead of enjoying a TV show, those 25 minutes are spent by a child, 3.5 years old, alone in a basement, tied where he can't leave? And what did he tell you he was scared of in the basement? Monsters. For 25 minutes, that's what he is left to think of. The monsters in the basement as he sits alone. Now, I want to go back to this forensic interview because there was part of it that even Junior didn't seem to understand from the stand. And I want you to listen to this clip. We're going to play it twice. We're going to play it. I'm going to ask you to listen for something, and we're going to play it again.
A black sock?
Yeah.
And what did Granny do with the black sock?
He put it on my,
On your foot?
yeah,
On one foot or more than one foot?
two on one.
Okay.
So it is black.
So Junior says something there, put it on my, and it starts with an F and it ends with a S. It's not real clear. Now, when you listen to it again, I want you to decide for yourself. But Junior, when he testified, was confused by what he had said on the video because he knew there wasn't a sock on his feet. He knew that was wrong. When he testified to you today, he knew it was wrong, but he didn't know why he said that. And I would submit to you that what Junior says here is the sock was on my face. But the interviewer mishears. And when she says feet, he doesn't know how to correct her. So when he sat in front of you yesterday, 2 days ago, and was told, you have to tell the truth, he was as truthful as he could be. He said, that video's wrong on that because the sock wasn't on my feet, it was on my face. So I'm going to let you listen to it again, and you can make a decision about what you think he says.
One.
A black sock?
Yeah.
And what did Granny do with the black sock?
He put it on my,
On your foot?
yeah,
On one foot or more than one foot?
two on one.
Okay.
So it is black.
Now, the judge gave you instructions at the beginning of the trial and the initial charge that included how to judge witness credibility. And I'd like you to keep those in consideration as we move to sort of the next part of my closing. Did he or she have any particular reason not to tell the truth? Did he or she have a personal interest in the outcome of the case? Did the witness have the opportunity and ability to observe accurately things he or she testified about? You know, Mr. Belmaris in jury selection said a phrase that jumped out to me immediately. Kids say the darndest things. So, as Junior testified, and as you heard the forensic interview video, I wrote down some of those darn things that Junior said. And I want to know, does this person impress you as honest? When he's asked if they have any pets, he says, we're about to get some rats. The interviewer is a little confused. So he says, yeah, that's what Daddy says if we keep leaving food out. Okay. When asked how he got hurt, he says, well, Granny tied me up and I got cut by glass. That's a description of all of his injuries. Okay. When asked again, he says, Granny tied me up real good and I couldn't get out. I was in the basement. When he's asked if something happened to his fingertips, he says, I don't know, because he doesn't know how those marks got on his fingertips. The marks from the pressure of the rope being tied around his wrist. Kid doesn't know. Makes sense. Interesting things when he's asked how he's feeling, he responds with how Jeremiah is feeling. Now, if you have two kids and you've ever had to discipline one in front of the other, there are usually one of two reactions. Either a ha-ha, you got in trouble, or have you ever been really mad? That child is really in trouble. And what does that sibling do? No, please don't be mad at my brother. Please don't be mad. Please don't hurt him. Is that why Jeremiah was feeling sad when Junior got in trouble? Another thing I wrote down that Junior said in his interview is when she asked, who takes care of you? He says, Daddy takes care of me from Granny. From Granny. Now in his testimony, again, my grandma tied me up. That's why I'm here. When asked the color of the rope, he says, the same color as ropes. Normal ropes. He doesn't have a word for it, but he's trying to describe it. All I remember is me just sitting in the basement being tied up. A sock pulled to right here. I was sad. I was scared of monsters. Kids say the darndest things. So do adults. Ms. Kelley said something interesting in her testimony. Her word choice was very interesting. When her attorney is asked, why did you wrap his arms in gauze? To keep his wounds clean. Wounds. She chose that word. Now, as I told you at the beginning, your job as the jury is to take the facts from the witness stand, the law the judge gives you, and the time has now come for me to ask you to make a decision. After the judge reads the law to you, you will go back in the jury room, and one of the things you will be given is a verdict form. Now, this is a condensed version, okay, because you have lesser included offenses that he's going to tell you about. But at this point, you have all the information you need to apply the law and reach a just verdict. To convict the defendant, find her guilty of aggravated child abuse, and to find her guilty of aggravated kidnapping.
Mr. Bell Mowers?
Ladies and gentlemen, thank you again for your patience in listening through all the proof here in this case, giving us an opportunity to summarize what the proof is. This is not a case about a fun summer at grandmother's house. This is a case about a grandmother who stood up time and time again to stand in the gap to take care of her grandchildren. You heard testimony that she provided a house for her son, his wife, his child, and then later his unborn child when they needed a place to live. You heard that she stood in and stood up when violence ensued in the household between them. You heard that whenever she was called on, she would go to the aid of her son to take care of her grandchildren. And you heard that in the summer of 2020, her son brought the children there for no particular reason and left them. And she stood up for them again to take care of them. Didn't bring anything with them because they didn't need it. Didn't provide any medical cards, documentation, any of that. It was her responsibility to take care of the children. Now, Mr. Clinton Sr. told us, well, I was taking some classes about my driver's license for 10 or more weeks, and they were twice a week. And so that's why I put that responsibility with Miss Kelley instead of taking the responsibility myself. Use your common sense about how far it is from Cumberland Furnace to Clarksville, and would a father stay away from 10 weeks because they were taking a class? You heard that Mr. Clinton didn't provide any financial support, anything there, and the children didn't really take any things with them when they went to grandmother's house. I think importantly, you heard that the father, you saw him on the witness stand, you saw his credibility, you can judge him, that he seemed inconvenienced by Miss Kelley calling him about his children. Why are you calling me about it? If you're not taking them to the hospital, why are you bothering me? Is that a normal response that a parent would have about their child? Wouldn't you want updates? Wouldn't you want to see them? Wouldn't you want to talk to them on the phone? Wouldn't you want to see them on video calls? Wouldn't you want to have contact with them? You heard that Miss Kelley attempted to follow the guidance of COVID-19, and she attempted to treat non-emergent injuries or problems at home. And despite those best efforts, she may or probably caused some injury to that child, trying to give medical care. Now, when you're piecing together what happened, I'd submit you should try to piece together everything and see if it can fit together. Everything, from both sides. That's what our law allows, that you should assume that witnesses are telling you the truth unless they've been impeached and proved to be not telling the truth. You heard from Dr. Aquino, and she read the note into the record. Raynell's dad does not recall a history of abuse when he was younger. His mother is not sure what happened, but denies that he can't be burned. Raynell's father called his mother while in the office on speakerphone. His mother yelled that she didn't know what happened, but he wasn't burned, and hung up the phone. Because she didn't know what the injuries were that they were talking about at that point. You heard Miss Kelley tell you that that binder of injuries that came from Vanderbilt, and you'll have it. You can look through it. You can look through each and every one of those pictures. They didn't look like that when he went home with his dad. Then she even came back and said, well, there was one picture that does, and we had to correct that issue. And ask yourselves this. You saw Mr. Clinton testify. You saw his temperament. You saw his demeanor on the stand. If he had came to Miss Kelley's house to pick those children up, and his hands look like that book, would Miss Patterson sitting on the porch a few yards away not have heard a commotion? Do you believe for a second that he would have just put his head down and said, all right, and put the kids in the car and drove home? One, would any normal parent do that? Any parent? At all. And two, with his temperament, you think he'd just keep a lid on it if he was upset? I would submit, ladies and gentlemen, it's impossible. With Mr. Clinton, that is impossible. I retrieved the exhibit.
Okay.
I don't have PowerPoints, but you can see from there. That's what Dad would have saw if those were in fact in that condition when he picked that child up. That's how far away the parking spots are from Miss Patterson's porch that she told you she was sitting on. Now, I talked with Dr. Keno quite a bit about Junior's history with their clinic. Father was religious about making those appointments every 6 months. But after being at Vanderbilt, he didn't take him to his burn visit. Why? Because he knew that the injuries that had presented at Vanderbilt were not there when he picked the child up from Miss Kelley. He knew that. He didn't want to go back to burn. He didn't want them to look into it further. He didn't want them to see anything else. This picture right here, if you pay close attention to it, this is exhibit 3D. You look at that picture, you'll see little blisters all around that bigger blister, new ones. You remember this was taken by DCS weeks later. Now, is that consistent with being tied up, or is that consistent with poison ivy infection or something else? That's why, another reason why I didn't want to follow up with her. He did follow up with his clinic. He did do that, where he had been so many times, where he knew the practitioners, where he had built rapport, and where he felt like he could control the situation. Now, we heard from Miss Deese, and she was telling us about the circumstances that presented with Mr. Clinton. And she thought, you know, maybe that was the reason why he didn't seek immediate care when picking the children up. Well, let's think about that for a second. He picked the children up in Cumberland Furnace and took them home to Clarksville. They're in the car. They're driving. If he had those injuries, what's the difference of just going to the hospital if he needed the medical attention? Again, it's because they weren't there. And why would a father that was so adamant about he disagreed with how mother took care of the children, that he was keeping the children away from the mother, that when they needed somewhere to stay for 10 weeks, he didn't let them go to the mother's house, he took them to his mother's house instead. Just weeks later, they'd be with the mother. And the mother took care of all the appointments after that. And he said, well, you know, they wanted their mother after what had happened. So if Junior had been injured by Miss Kelley, you think that they would want to stay with their mother, or you think they'd want to stay with their father? You know, that's just something to consider. And you saw him testify about discipline. You saw that child on that video General Bryson just showed you again. Is that a child that's big enough to appreciate getting whipped by a belt? Is that a child that's the appropriate way to handle a child? You heard Miss Kelley tell you how she disciplined children, and particularly that child, and why. And he told us that he had conditioned the child so much that he could show them a belt and they would straighten up. Now, is it possible that Junior was told before he went to the doctor, you don't tell them anything. You don't tell them anything about what happened, or you're going to get the belt? Is that why when he would go to the doctor, he said he didn't know, 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 didn't know all the way through any of the medical personnel what happened? Didn't know, didn't know. But the disclosure comes weeks later in September at the Child Advocacy Center with Dr. or Miss Post. I want to talk about that. General Bryson would ask you to watch a video and think, we're listening to audio of a child that we weren't familiar with, that we didn't talk to, and we're supposed to take and say, well, he said face, he didn't say feets. Now, Miss Post is an expert forensic examiner. The state put her on the stand. You heard her. She's done thousands and thousands of interviews with the child, with children. Is that someone that gets the word wrong when they're interviewing a child? And if so, if she did get the word wrong, and Mr. Clinton just as agreeable and just, yep. It was feet, 1 feet, 2 feet, and gets into all that, then isn't he agreeable and easily told what to say, suggested what to say? I mean, this is a child of 3 years old. What the state is asking you to do is to take that video and that statement and say, yes, you're supposed to make one of the most important decisions regarding Miss Kelley's entire life based on that. Would you make other life-changing decisions in your own life based on that? Would you take a stock tip from a 3-year-old? Would you go on a trip based on something a 3-year-old told you? Think about that. Ms. Post also testified about children and language and development and how that works. Now, General Bryson was talking about even when Junior testified that he didn't have the word for the color of rope, ordinary rope, right? And so that had to be developed. I would submit it's because he didn't know, because he wasn't tied up with a rope. He told us that he didn't really have any memory of what happened, very little memory of what happened, but he watched a video the day before, and in his memory, that's where he remembered from. Is that why he couldn't tell us about the color rope? Because he didn't remember and it wasn't on the video? She told us about that, and we had this long discussion about cars and trucks and children using words closest to what they're trying to describe. So ask yourself what a child of 3.5 to 4 years old would call galls. Now, we already heard that he was a healthy child, never really had any issues, maybe had some eczema or some skin problems that he had been treated with before, and that was it. There wasn't really anything about history of needing galls. So if a child's trying to describe galls that they had saw for the first time, what word would they use? I mean, it's stretched out, it's wrapped around, it's tying things, you tie your hands. What word would they use if they didn't have a word for it, if they didn't know what galls was? And in Junior's testimony, you heard him say, he didn't tell what happened because he was afraid to tell the truth. He said that right there on the stand. Because I was afraid to tell the truth. Was he afraid to tell the truth? If it was about Miss Kelley, she's not there. She's not at the hospital. He's not in her care. He's gone home to die. She's not standing next to him in the hospital room, at the ER, at the doctor visits, when this is being conveyed. The first time, the very first time of what we've heard, that he says to someone or tries to say or explain what happened, his dad's not in the room. Every other time his dad was right there. And Miss D said, well, he was very clingy to his dad. He's very clingy to his dad. And she thought, well, maybe that's, it's a bonding. But ask yourself, ladies and gentlemen, are there other reasons why you'd be very clingy to your dad? If he had been threatened, would you be clingy to your dad because you didn't want him to be out of the room because you were afraid he would think you told what you had been told not to say? You were afraid to tell the truth. Now, in order for you to find someone guilty beyond a reasonable doubt, you have to be able to expel or get rid or put away other possible causes or other possible things that might have happened. Is it possible that Junior was too young to describe that after he left Miss Kelley's house, that he had those bandages on his hands and he pulled and he tugged on them and he tried to get them off and he pulled and pulled and pulled and pulled and pulled, and that continued to make the injuries worse, to make these marks on his arm worse? Is that possible? Now, the doctor, if you remember, he was very, very careful not to talk about things being impossible or things being definite, right? He was very careful. So was Dr. Aquino. She told us, well, we don't try to make that stretch. Doctor said, I don't need to determine what caused something. I treat it, and if I have a suspicion or something like that, I'll report it. But in this case, he didn't have to report it because it had already been reported. It had already been reported to DCS. They had already started that process long before they ever got to Vanderbilt. So he's not even making that assessment. He's walking right in the room, already in his mind that this is non-accidental trauma, and so he's not really thinking about that. Junior testified from that stand that his hands were tied together behind his back. And I'm not built like him, so it's a little tougher, but behind your back, your hands would be tied like this, or it could be tied like this, one way or the other. When I asked the doctor, were those circumferential marks consistent with your hands being tied together, he said no. It's more consistent with his hands being tied apart. So if the state's asking you to say, well, Mr. Belmaris' theory or what Ms. Kelley testified to must be 100% false, that's what they're going to ask you to do. Disregard everything she said. Well, didn't he say the same thing as to what Junior said? The medical proof proves the injuries. And ladies and gentlemen, you see those injuries, you can make the decision on those injuries. It's right there in the book. Like I said in the beginning, there's some things that it is what it is. That kid was injured. But what you've got to ask yourself, was he injured by the actions of Miss Kelley? And what the state's saying is she tied him with a rope. So if they haven't proved beyond a reasonable doubt that she tied him with a rope and that Miss Kelley did it, then you must find her not guilty. Other theories, there are other people in the home. Levi Kelley was in the home. Now you heard from the stipulation from Ms. Deese that the father made a statement about Levi's history of being aggressive with the kids. Is it possible that Levi Kelley did it? Has that been proven that that's not the case? Or would that be a reasonable issue? And I just would go back to your common sense. Put your hands together either way and look at it. Would you have rings around your arms? One thing that the doctor did, I believe, concede about the poison oak is the linear could be from wrapping a vine around your arm when you're pulling, or wrapping an object around your arm that had it. That was possible. So when you talk about the linear thing, I mean, it's a vine. It's a vine much different than a rope. I mean, it's linear. It could cause ligature marks. During the forensic interview, he was asked about specific injuries and what caused this and what caused that. Everything on his hands, his fingers. Didn't know. I don't know. I don't know. I don't know. And would a child be able to explain, well, the rash just keeps coming back. It just pops up more places. And if you've ever had poison oak, think about it. Does it spread? Does it get on more places? Do you have it one place, another place, or not? Let's talk about that statement as well. So, Ms. Post is the expert. She's supposed to be finding out what happened. But she said that there was a pre-interview, so she knew about the case. She had those pictures when she walked in the room. So when the child said, "We're going to get some rats," he's like, "Well, that doesn't make any sense. Let me follow up. What does he mean by that?" That's exactly how a 3-year-old communicates. Everything out of context. "We're going to get some rats." Talk to him for a few minutes. "What do you mean about rats?" "Well, Daddy said if we keep leaving food down, we're going to get some rats." So if you would just ask the first question, "We're going to get some rats." And if that had been satisfactory or fit your theory, and you didn't ask any more questions regarding that, you would have never developed it. It would be left at that. When he said, "I was tied up with a rope," she didn't ask about the color of the rope, the length of the rope, any questions to try to get to the bottom of that to make sure what he was describing as rope actually meant rope. Never did. Because it fit the theory that she had already talked about. And when she walked in with those pictures, I mean, she had already talked about it, that's clear. Now, near the end of the forensic interview, he was asked, "How did you feel when you were tied up? Did something hurt?" "No." "Did somebody hurt you?" "No." Let's think about for a minute. If he had been tied up and a rope cinched down on him, would he have said, "Did somebody hurt you?" I think the answer would be yes. Did something hurt? I think the answer would be yes. But if it had been what Ms. Kelley says regarding the poison oak, it develops over time. Did somebody hurt you? No. Did it hurt when it started happening? No. When she put the gauze around him, would that hurt? No. When you look at the pictures, DCS there, he said, "I ripped it off and I seed it." It's very consistent with what Miss Kelley said, that when they were changing the gauze, she thinks it peeled that skin away on his wrist when they were changing the gauze when she was attempting to train Junior how to do it and take care of the kid. And his dad, Mr. Clinton, told us that, yet when he changed it out, he started bleeding. Ask yourself if you've wrapped up a festering or oozing blister that had started to scab over and you didn't keep it moist, what happens when you remove the bandage? Causes more injury. It pulls that out, rips it out. Then when asking to describe picture number 4, that child says, "That's the burn, the rope burn." Ask yourself this, how many 3-year-olds do you know that you've used the term rope burn? Is that in his regular vocabulary? Is that something he would use to describe? Or is that something that someone else had told him? Now, you also heard in evidence, you also heard from Agent Humphreys that she was part of the team that handled the investigation, but the DCS investigators spoke to the children. The DCS investigators attended the CAC interview. Clarksville Police did the initial investigation when the police were first called. She didn't interview Mr. Clinton Sr., but she did talk to him on the phone once, or ever meet with him in person. That she received medical records from Vanderbilt. Now, if you recall, that Ms. Deese, when I was asking her about did she see photos, and she looked through the record and said, yes, I saw photos. She had to look at the records because the record said that she saw photos. But yet the state didn't go out and talk to Raynell because he showed her a photo on his phone. My mom sent this to me, and get his phone to see if he had any other messages or anything like that. They didn't go out and seek that information or get his phone or subpoena his phone or any of that. Miss Kelley told you what happened with her phone. She tried to provide pictures as much best she could. She told you what happened. And that's how those investigations fit together, but we didn't hear from DCS. Agent Humphreys told you that she continued to investigate even after the charges were brought. She went out, she talked to Mr. and Miss Mathers and Miss Patterson. Now, she went out and talked to them. She saw the place, she talked to it, she asked them, did they see or hear anything? And they talked to her, told her what had happened. Almost exactly what Miss Patterson said. Now, when General Bryson's is talking about credibility of a witness, who has testified that has absolutely nothing to gain or lose by this case? Miss Patterson. Did she strike you as someone that would have seen the injuries in that binder that I've held up and showed you and not called the police? She also told you about her mother and father, or her adopted mother and father, that they weren't the kind of folks that wouldn't call the police. General Bryson said, well, how come she wouldn't have saw the galls when the kids were outside? Well, why? Patricia Kelley told you. I'd let it breathe. When you're treating things, do you let it breathe when you're out and about during the day? And would you wrap it up at night especially if you were sleeping with 2 other people? If you had your child or your grandchild laying next to you on an ottoman, both of them, would you wrap it up at night? Would you put sleeves on their arms and long socks to make sure that they wasn't rubbing it all over you, all over each other, all over themselves? Now, I want to talk about the jury charge just a second, and then we're going to go through a few more things, but it'll be on page 9 of your jury charge. Removal or confinement is unlawful if accomplished by force, threat, or fraud, or in the case of a person who is under the age of 13, if it is accomplished without the consent of the parent. General Bryson told you about that. That's what it says. And she said she asked, did you have consent of the parent to do that? She asked Dad, did you have, but it goes on. Guardian or other person responsible for the general supervision of the minor's welfare. Now, if a kid's dropped off in your care for 10 weeks or longer, aren't you a person responsible for the general supervision of the minor's welfare? Stop short. It's right there on your jury charge. You'll see it. In count one, in order for you to find Ms. Kelley guilty, the state must prove beyond a reasonable doubt to a moral certainty. To a moral certainty. And I would submit if you go home and you wonder if you made the right decision, you're wrong. You wasn't a moral certainty. One of our judges used to say, it has to let the mind rest easy. If it doesn't, then that's reasonable doubt. That Ms. Kelley treated Junior Clinton in such a manner as to inflict injury, that she knowingly treated him in such a manner as to inflict injury. Knowingly, other by accidental means. And the act of abuse resulted in serious bodily injury, and that he was less than 8 years old. I would submit, ladies and gentlemen, that if she's putting his hands in Epsom salt and that somehow caused these blisters in his hands, then she would have to know that that wasn't the proper treatment. And take what she said in your common sense. Does Epsom salt boil things out? Cause it to blister, or does it dry things out? Does it suck up a blister? What about hydrogen peroxide? Could that explain why those blisters on the hands appeared and got bigger while he was with Dad and in Dad's care? That he was putting hydrogen peroxide on it. He told you that he had got some hydrogen peroxide, that Miss Kelley had given supplies, that he got hydrogen peroxide. That she knew, knowingly, that it was the wrong thing to do and it could cause serious bodily injury. But even if you disregard Miss Kelley's testimony, even if you disregard that Levi was in the home, even if you disregard Dad's temperament and everything you've seen on the witness stand, and you think, okay, she did tie him up with a rope, you have to ask yourself, why? Did she know if she did, it would cause injury? Ladies and gentlemen, I would submit to you the proof does not get anywhere near beyond a reasonable doubt. Likewise, there's not proof. There's going to be several lesser included offenses. There's not proof of aggravated assault. There's absolutely nothing to say that Miss Kelley purposely, intentionally was trying to harm that child. But if you believe that she did tie him up and she didn't think about what could happen, then you should consider reckless assault, which is in assault, which can be by recklessness, which is in the jury charge. And there's nothing to support reckless endangerment. In count two of the indictment, in order to find Ms. Kelley guilty, the state must prove that she knowingly removed or confined Junior Clinton by force, by threat, or fraud, or he's under the age of 13 without consent of the parent, guardian, or other person responsible for the general supervision of Junior's welfare, and that it was done with the intent to terrorize Junior. It also gets much, much more complicated. The simple way to explain it is this. In order for you, if you believe that she tied him up, you believe everything the state's asking you to believe, then you have to believe, in order to find her guilty of kidnapping, that the tying up was more than necessary to cause the child abuse and the injuries. Now, if you believe everything they've told you, if you believe that theory 100%, the injuries were caused by what? Being tied up for a length of time. I think she said at least 24 minutes. So how can you separate and say that the kidnapping is in addition to the child abuse? And she said, well, it's not like putting somebody in a trunk, but that's it. That's exactly what it is. That's what kidnapping is. If I intend to beat someone up and I throw them in my trunk and take them somewhere and beat them up, then I'm guilty of assault and kidnapping. Or I've got to beat them up pretty bad or use a weapon, aggravated assault and kidnapping. Because I didn't need to kidnap them to beat them up or use a weapon against them, but I did. But if it's the same act, if it's together, then it's not kidnapping. It has to be extra. It has to be more than what was required. Ladies and gentlemen, you've heard all the proof in this case. You've seen the exhibits. You're going to have an opportunity to look at them again. You have to try to reconcile everything you've heard. Does it make sense that a woman that has taken in her children and grandchildren time and time again has stood in the gap to take care of those children anytime she's asked, that was willing to take the children in for the summer for really, it seems like no real reason at all, suddenly decided to take a child down in the basement, tie him up, cause serious bodily injury, and try to terrorize him? She just suddenly did that out of nowhere. Does that make any sense? Or does it make sense that things happen over the course of a summer and a young child is trying to explain and the timelines get crushed, everything gets blended together. We talked to the expert about that. It gets together. Think about if you ever talk to a 3-year-old, can they tell you this happened last week, this happened last month, this happened weeks ago? They can't. The doctor tells us what's consistent and what's inconsistent, but remember this. There were other things that were of concern. They thought he had a broken bone. That was the thing they thought. He had a distended tummy or stomach, and they wanted to check for internal bleeding. Doctors make hypotheses, they make a theory, and they test it. Sometimes it tests out to be true, sometimes it doesn't. When they x-rayed his arm, if it would have been broken, they would have saw it. When they looked at it, it wasn't there. Not a broken bone. Well, what did he tell us? Well, we don't have a magic test that tells us when an injury happened and when an injury didn't happen. He's got to take everything he's told and reach a conclusion. But what was he told? He was told what Mr. Clinton Sr. wanted him to know. A man who was afraid because he had a previous case with the state and DCS. Really couldn't explain because he really didn't know what happened and how this kept getting worse and worse and worse. But he was afraid. He was scared. Ladies and gentlemen, the proof shows that Miss Kelley didn't commit these crimes. She didn't tie that kid up. She didn't hurt that child. And in order to find that, you must make a lot of big leaps and you must disregard a lot of things.
Colonel Bryson, you wish to respond?
Poor Miss Kelley. She had to take care of her grandbabies for 10 weeks. Poor Miss Kelley. She didn't have the insurance cards. She had to feed them. She had to deal with them breaking the styrofoam tile off her wall. Poor Miss Kelley. Let's talk about Nedra Patterson. She didn't know if she was sitting on her porch when the kids left. She didn't know if she was in the yard. She was somewhere and she waved at them. But Miss Kelley, or Miss Patterson, maybe she didn't see the galls. But should she have seen some of these injuries? The injuries that the defendant has told you that this child had? Let me see the constellation slide. Injury was present when the child left. Oh, was this one that's weeks older? Patterson didn't notice those. Didn't notice the scratch on his head. Oh, not the big one. That one wasn't there when he left. It must have been the tiny one. That's what he got falling off the steps. You were asked by the defense who has nothing to gain or lose. You were asked by the defense what you would base important decisions in your own life on. Does Dr. Long have anything to gain or lose? Would you base important life decisions like the treatment of one of your own medical conditions on the advice and opinions of a Vanderbilt doctor? A doctor who tells you the timeline on this event. And that timeline is so important. Ladies and gentlemen, you don't have to like Raynell Clinton Sr. to know that he didn't cause these injuries. He didn't have time to. You don't have to like him. You can dislike him. You can hate his guts. You can wish he didn't have care of his kids. You can think all of those things, and that still doesn't mean that he did this. The defense has thrown out so many things. Maybe Raynell did it. Maybe Levi did it. Maybe it's poison ivy. Maybe it was the gauze, which, by the way, gauze is white. Not brown. Not even light brown. All the way around the court. White in this room that he could point to say the rope was white? You think a child doesn't know the color white? Or is it more likely that he doesn't know the word tan for light brown? Who hurt you? How did you get hurt? How did you feel? When he's asked about feelings, he talks about emotions. When a 3-year-old is asked who hurt you, how does he process that? Can he understand the rope hurt him? Or does he understand that he got in trouble? Who hurt you? But you know what he can say? Who tied you up? Her. Did Dad tie you up? No. Did Levi tie you up? No. Granny tied me up. And how do you know that the kidnapping is over and above the abuse? The ties caused the injury. The sock caused the terror. Being left alone, immobile, unable to see for a protracted period of time, long enough to cause those blood and blisters, down where the monsters could get him. Could he have been tied up anywhere else in the house? Which that's an interesting note. You also now have the possibility, maybe she did it, but she didn't mean to. So let's take that. What if she tied him up on the front porch in the sunlight with other people around? Granted, people could see. Would that have been terrorizing? Or is the terror where he was tied up, where he was left, and how all of his senses were cut off while he was there? Terror for a 3.5-year-old little boy. You have what you need.
Ladies and gentlemen, the next step will be for me to read you about a 20-page set of final instructions, and that's going to take a while. Would you rather go to lunch and then come back and let me give you the instructions? After I've read the instructions, I will excuse the 2 alternates, and then you'll begin your deliberations. I'll give you the option. We can keep going. Let me read the instructions, excuse the alternates, and then you can take your lunch if you would rather do it that way. Anybody need a bathroom break or anything? All right, that's what I figured. So, well, if we're going to take a bathroom break, let's go ahead and just come back at 1:15 for, we'll break for lunch until 1:15, and then we'll try to be back here at 1:15. If you're a little later, that's okay. We will break for lunch at 1. Now, I have given you a set of instructions orally and at the beginning. It's very important. You've now heard all the proof. You should not begin any deliberations or discussions about this case until I have given you my final set of instructions. So don't talk about this case, don't discuss it, don't let anyone, again, don't try to do any research about it. When we come back, I will give you the final set of instructions, and then you begin your deliberation. We'll stand at recess to 1:15.
All rise. This court's now in recess until 1:15.
To bring the jury out, I've got their copies here. If you will hand them out to them when they come out. All right, ladies and gentlemen, if you will follow along with me, we'll read the final charge of the court. Ladies and gentlemen of the jury, the defendant Patricia D. Kelley is charged in count 1 in the indictment with the crime of aggravated child abuse. Necessarily included within a charge of aggravated child abuse are the lesser included offenses of aggravated assault, reckless endangerment, and child abuse. The defendant is charged in count 2 of the indictment with the crime of aggravated kidnapping. Necessarily included within a charge of aggravated, well, I'm sorry, Miss Pam, I started without you. You okay? Can you tell we're anxious to get started? So, all right, are you ready? All right, we're just down to about the second sentence. Necessarily included within a charge of aggravated kidnapping are the lesser included offenses of kidnapping and false imprisonment. The defendant pleads not guilty to each count in the indictment and to all offenses contained therein. The evidence and arguments in this case have been completed, and it is my duty now to instruct you as to the law. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out one or more of them to the exclusion of another or others, but should consider each one in the light of and in harmony with the others. The law presumes that the defendant is innocent of the charges against her. This presumption remains with the defendant throughout every stage of the trial, and it is not overcome unless from all of the evidence in the case you are convinced beyond a reasonable doubt that the defendant is guilty. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts but remains on the state throughout the trial of the case. The defendant is not required to prove her innocence. Reasonable doubt is that doubt created by an investigation of all of the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of proof necessary to constitute the offense. The state must prove beyond a reasonable doubt all of the elements of the crime charged, that the crime, if in fact committed, was committed by this defendant in Dixon County, Tennessee, and that it was committed before the finding and returning of the presentment in this case. As heretofore stated, in count 1 of the indictment, the defendant is charged with the crime of aggravated child abuse. Any person who commits the offense of aggravated child abuse is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly, other than by accidental means, treated a child in such a manner as to inflict injury. And 2, that the act of abuse resulted in serious bodily injury to the child. And 3, that the child was 8 years of age or less. Serious bodily injury to a child means bodily injury that involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, or protracted loss or substantial impairment of the function of a bodily member, organ, or mental faculty, or a broken bone of a child who is 8 years of age or less. Serious bodily injury to the child includes but is not limited to second or third degree burns, a fracture of any bone, a concussion, subdural or subarachnoid bleeding, retinal hemorrhage, cerebral edema, brain contusion, injuries to the skin that involve severe bruising or the likelihood of permanent or protracted disfigurement, including those sustained by whipping children with objects. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct when it is the person's conscious objective or desire to engage in the conduct. If you find the defendant guilty of aggravated child abuse as charged in count 1 of the indictment, you shall so state and proceed to count 2. On the other hand, if you do not find that the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to her guilt of aggravated child abuse, then you shall acquit the defendant of this offense and proceed to inquire as to whether or not the defendant is guilty of the lesser offense of aggravated assault. Any person who commits the offense of aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intentionally or knowingly caused bodily injury to another, and 2, that the defendant caused serious bodily injury to another. If you find the defendant guilty of aggravated assault as a lesser included offense of aggravated child abuse, you shall so state and proceed to count 2. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to her guilt of aggravated assault, you shall acquit the defendant of this offense and proceed to inquire as to whether or not the defendant is guilty of the lesser offense of assault. Any person who commits an assault upon another is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant caused bodily injury to another, or 2, that the defendant acted either intentionally, knowingly, or recklessly. Recklessly means that a person acts recklessly with respect to the circumstances surrounding the conduct or the result of the conduct when the person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all of the circumstances as viewed from the accused person's standpoint. If you find the defendant guilty of assault as the lesser included offense of aggravated child abuse, you shall so state and proceed to count 2. On the other hand, if you do not find that the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to her guilt of assault, you shall acquit the defendant of this offense and proceed to inquire as to whether or not the defendant is guilty of the lesser offense of reckless endangerment. Any person who commits the offense of reckless endangerment is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant engaged in conduct which placed or might have placed another person in imminent danger of death or serious bodily injury, and 2, that the defendant acted recklessly. For the threat of death or serious bodily injury to be imminent, a person must be placed in a reasonable probability of danger as opposed to a mere possibility of danger. Before you can convict the defendant, the state must show beyond a reasonable doubt that a person or a class of persons was in the zone of danger. The zone of danger is that area in which a reasonable probability exists that the defendant's conduct would place others in imminent danger of death or serious bodily injury. If you find the defendant guilty of reckless endangerment as a lesser included offense of aggravated child abuse, you shall so state and proceed to count 2. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to her guilt of reckless endangerment, you shall acquit the defendant of this offense and proceed to inquire as to whether or not the defendant is guilty of the lesser offense of child abuse. Any person who commits the offense of child abuse is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the defendant knowingly, other than by accidental means, treated a child under 18 years of age in such a manner as to inflict injury. And two, that the child was 8 years of age or less. If you find the defendant guilty of child abuse as a lesser included offense of aggravated child abuse, you shall so state and proceed to count 2. On the other hand, if you do not find that the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to her guilt of child abuse, you shall acquit the defendant of this offense and proceed to count 2. As heretofore stated in count 2 in the indictment, the defendant is charged with the crime of aggravated kidnapping. Any person who commits an aggravated kidnapping is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the defendant knowingly removed or confined another unlawfully so as to interfere substantially with the other's liberty. And two, that the defendant did so with the intent to terrorize the alleged victim. A removal or confinement is unlawful if it is accomplished by force, threat, or fraud, or in the case of a person who is under the age of 13, if it is accomplished without the consent of a parent, guardian, or other person responsible for the general supervision of the minor's welfare. Although the law requires no specific period of time for confinement or distance of removal, a removal or confinement interferes substantially with another's liberty if the time of confinement is significant or the distance of removal is considerable. To find the defendant guilty of this offense, you must also find beyond a reasonable doubt that the removal or confinement was to a greater degree than that necessary to commit the offense of aggravated child abuse as charged in count 1. In making this determination, you may consider all of the relevant facts and circumstances of the case, including but not limited to the following factors: the nature and duration of the alleged victim's removal or confinement by the defendant, whether the removal or confinement occurred during the commission of the separate offense, whether the interference with the alleged victim's liberty was inherent in the nature of the separate offense, whether the removal or confinement prevented the alleged victim from summoning assistance, although the defendant need not have succeeded in preventing the alleged victim from doing so, whether the removal or confinement reduced the defendant's risk of detection, although the defendant need not have succeeded in this objective, and whether the removal or confinement created a significant danger or increased the alleged victim's risk of harm independent of that posed by the separate offense. Unless you find beyond a reasonable doubt that the alleged victim's removal or confinement exceeded that which was necessary to accomplish the alleged aggravated child abuse and was not essentially incidental to it, you must find the defendant not guilty of aggravated kidnapping. Terrorize means to use or threaten violence to intimidate or cause panic. If you find the defendant guilty of aggravated kidnapping as charged in count 2 in the indictment, you shall so state. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to her guilt of aggravated kidnapping, then you shall acquit the defendant of this offense and proceed to inquire as to whether or not the defendant is guilty of the lesser offense of kidnapping. Any person who commits the offense of kidnapping is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the defendant knowingly removed or confined another unlawfully so as to interfere substantially with the other's liberty. Two, that the removal or confinement was under circumstances that exposed the other to substantial risk of bodily injury. A removal or confinement is unlawful if it is accomplished by force, threat, or fraud, or in the case of a person who is under the age of 13, if it is accomplished without the consent of a parent, guardian, or other person responsible for the general supervision of the minor's welfare. Although the law requires no specific period of time for confinement or distance or removal, a removal or confinement interferes substantially with another's liberty if at the time of confinement is significant or the distance of removal is considerable. To find the defendant guilty of this offense, you must also find beyond a reasonable doubt that the removal or confinement was to a greater degree than that necessary to commit the offense of aggravated child abuse as charged in count 1. In making this determination, you may consider all of the relevant facts and circumstances of the case, including but not limited to the following factors: the nature and duration of the alleged victim's removal or confinement by the defendant, whether the removal or confinement occurred during the commission of the separate offense, whether the interference with the alleged victim's liberty was inherent in the nature of the separate offense, whether the removal or confinement prevented the alleged victim from summoning assistance, although the defendant need not have succeeded in preventing the alleged victim from doing so, whether the removal or confinement reduced the defendant's risk of detection, although the defendant need not have succeeded in this objective, and whether the removal or confinement created a significant danger or increased the alleged victim's risk of harm independent of that posed by the separate offense. Unless you find beyond a reasonable doubt that the alleged victim's removal or confinement exceeded that which was necessary to accomplish the alleged aggravated child abuse and was not essentially incidental to it, you must find the defendant not guilty of kidnapping. If you find the defendant guilty of kidnapping as a lesser included offense of aggravated kidnapping, you shall so state. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to her guilt of kidnapping, you shall acquit the defendant of this offense and inquire as to whether or not the defendant is guilty of the lesser offense of false imprisonment. Any person who commits the offense of false imprisonment is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant removed or confined another unlawfully so as to interfere substantially with the other's liberty. 2, that the defendant acted knowingly. To find the defendant guilty of this offense, you must also find beyond a reasonable doubt that the removal or confinement was to a greater degree than that necessary to commit the offense of aggravated child abuse as charged in count 1. In making this determination, you may consider all of the relevant facts and circumstances of the case, including but not limited to the following factors: the nature and duration of the alleged victim's removal or confinement by the defendant, whether the removal or confinement occurred during the commission of the separate offense, whether the interference with the alleged victim's liberty was inherent in the nature of the separate offense, whether the removal or confinement prevented the alleged victim from summoning assistance, although the defendant need not have succeeded in preventing the alleged victim from doing so, whether the removal or confinement reduced the defendant's risk of detection, although the defendant need not have succeeded in this objective, and whether the removal or confinement created a significant danger or increased the alleged victim's risk of harm independent of that posed by the separate offense. Unless you find beyond a reasonable doubt that the alleged victim's removal or confinement exceeded that which was necessary to accomplish the alleged aggravated child abuse and was not essentially incidental to it, you must find the defendant not guilty of this false imprisonment. If you find the defendant guilty of false imprisonment as a lesser included offense of aggravated kidnapping, you shall so state. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to her guilt of false imprisonment, then you shall acquit the defendant of this offense. During the trial, you heard expert testimony. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact and issue, a witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state opinions concerning such matters and give reasons for their testimony. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept this opinion. The same as with any other witness, it is up to you to decide whether you believe this testimony and choose to rely upon it. Part of that decision will depend on your judgment about whether the witness's background or training and experience is sufficient for the witness to give the expert opinion that you heard. You must decide whether the witness's opinions were based on sound reasons, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all of the other evidence in the case. It is your duty as jurors to consult with one another to deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. When you retire to the jury room, you will first select one of your members as foreman or forelady who will preside over your deliberations. When you have reached a verdict, you will return with it to this courtroom, and your foreman or forelady will announce it. The defendant is charged in 2 separate counts of the indictment. Although these cases are being tried together, they are separate and distinct cases. You must decide each case separately on the law and evidence applicable to it, just as though each case was being tried separately. You will be asked to render a verdict as to each count of the indictment. The defendant may be found guilty or not guilty on any or all of the offenses charged. Your finding as to each crime charged must be stated in your verdict. In reaching your verdict, you shall first consider the offense charged in each count of the indictment. If you unanimously find the defendant guilty of that offense beyond a reasonable doubt, you shall return a verdict of guilty for that offense as to the defendant. If you unanimously find the defendant not guilty of that offense or have a reasonable doubt of that particular defendant's guilt of that offense, you shall find the defendant not guilty, and you shall then proceed to consider whether or not the defendant is guilty of the next lesser included offense in order from greatest to least, if a lesser included offense is included. You shall not proceed to consider any lesser included offense until you have first made a unanimous determination that the particular defendant is not guilty of the immediately preceding greater offense, or you unanimously have a reasonable doubt of that particular defendant's guilt of that offense. If you have a reasonable doubt of the guilt of the defendant as to all offenses charged and included in each count of the indictment, you shall return a verdict of not guilty as to that count. If you find the state has proven the defendant guilty beyond a reasonable doubt, then you should find her guilty. In that event, your foreperson will report that you find the defendant guilty and will name the offense agreed upon. On the other hand, if you find the state has not proven beyond a reasonable doubt the defendant's guilt, or if you have a reasonable doubt as to her guilt, then you must find her not guilty. In that event, your foreperson will report that you find the defendant not guilty. If after your deliberations you find the defendant guilty of any offense, the court will set the punishment at a separate sentencing hearing. The jury will not be involved in setting the punishment. You are reminded that you are required to report a verdict or failure to agree on all counts of the indictments. Now, before you retire to begin your deliberations, I will now select 2 of your number to serve as alternates, and you will be excused if you are an alternate. Mr. Bradford, you will be an alternate. That means you're released. You can stay around if you'd like and see what happens, or you may be on your way. Thank you for your help. The next one. You have anything back in the room?
Charles Cliff.
All right, we'll give you the button. Ladies and gentlemen, those of you who are remaining are the 12 who will decide this case, and I have prepared a verdict form that will go back with you. That verdict form has each count, each indictment, and all of the counts, and you will start at the top, the first as the count as it is indicted on count 1, and then you'll decide guilty or not guilty on that, and then if you go through it, I think it's self-explanatory, but it'll help you make that decision. You'll pass that to them, they'll take that back to the jury. Ladies and gentlemen, if you want to look at any of the exhibits will go back with you, except that if you want to watch any of the videos that were shown, then you'll have to come back into the courtroom to watch those. So just let the bailiff know if you want to do that. We will stand in recess pending the return of the honorable jury.
All rise.
Jurors may go across to the room.
This court's now in recess.
I've been handed a, sorry.
I was close.
All right, I've been handed a question, it's actually not a question, I think it's a request by the jury, and it just simply states, original criminal investigation report. Was there an original investigation report that was made an exhibit to this case?
During Ms. McCartney's testimony, I believe Mr. Belmaris handed it to her.
But it was never made an exhibit.
No,
Okay, all right. I'm going to bring the jury in and explain to them that there was some reference made to an investigative report, but it was never made a part of that. And normally investigative reports are hearsay and not admissible. But we'll go ahead and bring the jury in. I'll explain to them. They have the exhibits, and that's what they'll have to make the decision from. Ladies and gentlemen, I've been handed a sheet of paper that says original criminal investigative report, and I think that is a request by someone on the jury for to know whether or not that can be shown to you. During the trial, there was a reference made during a cross-examination of Agent Humphreys that about an original investigative report. That was never made an exhibit to this trial, so therefore it's not something that you can now look at. Normally, police reports are what we call hearsay, and they're not admissible in most trials. There are certain circumstances where that could be permitted, but this one was never made an exhibit. So you must decide this case without having that to refer to. All right? Thank you. Any other questions you have, you just let us know. Thank you. We'll stand in recess pending the return of the jury.
All rise. Court is now back in recess.
Where'd General Bryson go? Go ahead and bring the jury in. All right, ladies and gentlemen, I was told that you've requested an opportunity to take a break, and that's certainly fine. What I wanted to do is let's just take about a 15-minute recess if that's what you'd like to do. And I know some of you like to go outside and smoke. So what I'm going to do is to tell you the following. You cannot discuss this case unless all 12 of you are in the room. So if you take this recess, wait till everyone's back in the jury room before you begin deliberations again, okay? Let's give you about a 15-minute recess. Come back in at 4 o'clock, and by then, you can come back in earlier, but at least by 4 o'clock, okay? All right, we'll be in recess until the jury returns.
All rise. Back in recess.
About to get her.
All right, I've been handed a note from the jury that simply says the following: additional definition of reckless endangerment, and if it includes, quote, not taking action, end quote. I'm going to bring the jury back in and explain to them that the definition that the law allows of reckless endangerment is set forth in the charge. I'm going to read it to them again, and then I'm going to tell them that's the only definition that the law allows. Bring the jury in. All right, ladies and gentlemen, I've been handed a note that was sent out saying the following: additional definition of reckless endangerment, and if it includes, quote, not taking action, end quote. The charge that I have given you contains the only definition of reckless endangerment that the law allows. I'm going to read that to you again because that's the definition you have to use to determine whether or not the evidence has presented a case beyond a reasonable doubt of that offense, if you're down to that. Any person who commits the offense of reckless endangerment is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the defendant engaged in conduct which placed or might have placed another person in imminent danger of death or serious bodily injury. And two, that the defendant acted recklessly. For the threat of death or serious bodily injury to be imminent, The person must be placed in a reasonable probability of danger as opposed to a mere possibility of danger. Before you can convict the defendant, the state must show beyond a reasonable doubt that the person or class of persons was in a zone of danger. The zone of danger is that area in which a reasonable probability exists that the defendant's conduct would place others in immediate danger of death or serious bodily injury. That is the definition that the law allows. We're given a set of instructions that are called the pattern jury instructions, and that is the instruction that I can give you, and that is the only instruction I can give. I cannot give you another definition of the offense of reckless endangerment. So use that information, if you will, and retire to continue your deliberations if you think they're fruitful. So, all right, thank you. We will stand to recess pending the return of the jury.
All rise. Back in recess.
General Bryson?
Judge, as we had in our conversation in chambers, where we noticed that the lesser included of child abuse is actually out of order from the other lesser included. My request would be that because they have not given us a verdict yet, I think the appropriate remedy would be to ask them to stop deliberating until we can fix it and give them the correct offenses in order.
And when do you want them to come back?
I don't have any easy answers.
I can't
but
fix it tonight. It'll have to be another day. Mr. Belmars? Turn your microphone on if it's not already.
The offenses as listed, child abuse would be at the bottom, but for the surplusage of the additional element of finding a child under 8. If that element of the offense wasn't there, child abuse is in the proper location.
And that is the problem. It is listed in the order that's shown by the administrative officer of the court's information that shows all lesser included offenses of all crimes, and therefore the child abuse is shown in the proper order, but because it included a statement that of a child under 8 makes it a more serious felony than reckless endangerment, a more serious crime than reckless endangerment. And therefore, it is potentially out of the thing. I've been told that the jury has a verdict, so a little late in the game for us to do anything. We're going to bring the jury in, find out what their verdict is, and then at that point, I will take the appropriate action if any action is required. Bring the jury in. All right, thank you, ladies and gentlemen. I've been told by the bailiffs that you have reached a verdict, so is the foreman standing? All right, if you will, let's go through this verdict form. Let me go through it with you. As to count one of the indictment on the charge of aggravated child abuse, how does the jury find? Guilty or not guilty? As to the lesser included offense of aggravated assault, how does the jury find? Guilty or not guilty? As to the charge, not guilty. As to the charge of assault, how does the jury find? Guilty or not guilty? Pardon me for my turn of the page. As to the lesser included offense of reckless endangerment, how does the jury find? Guilty or not guilty? Find guilty of reckless endangerment? All right. On count 2 of the indictment, as to the charge of aggravated kidnapping, the jury finds the defendant guilty or not guilty? As to the charge of the lesser included offense of kidnapping, does the jury find guilty or not guilty? And lastly, as to the charge of false imprisonment, does the jury find guilty or not guilty? So that I'm clear, the jury has found the defendant guilty of reckless endangerment, and that is the only charge upon which they have found. Ladies and gentlemen, if you will signify this is your verdict by raising your hand. If it's unanimous, if you'll raise your hand to signify that it is unanimous. Show that the verdict is unanimous of the jury. Thank you, ladies and gentlemen. You may step out, and you are discharged from any further responsibility in this case. So. All right. The jury has found the defendant guilty of reckless endangerment, and that's the only charge upon which he has been found guilty. As a result of that, we will need to address this issue of whether or not there is any problem with the charge, but it seems to me that that has been resolved by the fact that the jury found on a charge not involving the misstatement of the classification. But in any event, we need to set a sentencing hearing date and order a pre-sentence report. I'm going to step off and get my calendar so that we can set the pre-sentence report. Right back. All right. It would appear to me that the most logical time for this would be in January when, unless there's some opposition, January the 17th. Mr. Belmars?
Should be fine, Your Honor.
January 17th for the sentencing hearing. At this point, I'm going to release the defendant on the present bond and pending that sentencing hearing. So. All right, and we stand adjourned.